Jack Smith, the special counsel, so-called, got a secret search warrant to go and raid Trump's Twitter account. These people are opening every single crevice that they can squeeze themselves into. They're used to this type of behavior, and they are doing it against Donald Trump. The Court of Appeals issued this ruling, and it is just recently unsealed. They decided it some time ago, and this has been battling for quite some time. We're just hearing about it because it has finished its appeal process. So this has already been something that's happened. So directly to the Court of Appeals, we see this is what it looks like. It is a 34-page filing, an opinion in a sealed case. This filed on August 9, 2023 out of the DC Circuit Court of Appeals. This is the public copy because they sealed the rest of it. All of the sealed information has been deleted because this involves Donald Trump and the special counsel. So you see all the people here who are a part of this, and we now have the circuit judge from the Court of Appeals writing, justifying this search warrant. They say the district court, the lower level court, issued a search warrant in a criminal case, directing appellant Twitter to produce information related to real Donald Trump on Twitter. The search warrant was served along with a non-disclosure order that prohibited Twitter from notifying anyone about the existence of the contents of the warrant. So give us your files and don't you even say anything about it. Twitter initially delayed production of the materials required by the search warrant while it unsuccessfully litigated objections to the non-disclosure order. So now this is Elon's Twitter at some point saying, we have free speech, we can talk about this. Twitter ultimately complied with the warrant, but the company did not fully produce the information until 3 days after the court order deadline. So the district court, when Twitter failed to comply with their demand to turn over Trump's private information, the district court held Twitter in contempt. $350,000 sanction. Woo, baby, that's a big one. So Twitter is obviously appealing this. In this appeal, Twitter argues that the non-disclosure order violated the First Amendment, and the district court should have stayed its enforcement of the search warrant until after Twitter objections were resolved. So the judge decided, yeah, search warrant granted and non-disclosure granted, and that should have been heard. So they say that the district court, the lower level DC Circuit Court, abused its discretion by holding Twitter in contempt and by opposing the sanction. How dare you? Okay, so Twitter ultimately turned everything over, but they did it 3 days late. How dare you do that to a judge? Almost feels like you're doing it intentionally, and so you're going to be in big problem. This is the Court of Appeals. We affirm the district court in all respects. So Elon and Twitter, sorry, you don't get your free speech, your non-disclosure stuff. You comply with what we say. Otherwise, $350,000. This is the strong arm of the federal government acting through the DC Circuit Courts. Now, they say portions of this sealed information has been redacted, and they say during the pendency of this appeal, Twitter changed its name to X. Now, they say here, sealed information has been deleted. So the Stored Communication Act permits the government to obtain a search warrant. A service provider that receives an order to produce subscriber data can move to quash or modify the order by showing that the information requested is unusually voluminous or it would cause undue burden. The act allows the government to seek a non-disclosure order. They're saying the judge basically has the authority to grant this if the following laws are met. A court shall enter a non-disclosure order if the following. There's a possibility of any one of these 5 enumerated harms. So remember what happened here, just technically. Trump is just sitting around at home. He's not doing anything, right? He's planning to save America. And Jack Smith and his little prosecutors are scurrying around trying to gobble up whatever evidence they can find. So they send a notice and a warrant over to Twitter. And ordinarily Twitter would say, hey, we've got a notice, so we're going to notify Trump. But they say you're not allowed to even notify him, and you have to give us this stuff. And the judge is now saying, well, that's allowed if you can prove any of these 5 things. 1, endangering the life or the physical safety of an individual. Okay, so if Trump is notified about this, is anybody's life going to be in danger? I don't know. Flight from prosecution. So if Trump is notified, if we have to disclose this to him, could he maybe flee prosecution? Destruction or tampering with evidence. Maybe he's going to get on Twitter and start deleting his stuff. Or intimidation of potential witnesses. Or seriously jeopardize the investigation. They say that's when the government, right? These rules are all written for them. They all write these rules for themselves. If any one of those harms is met, they can ask for a non-disclosure. So again, we're in the Court of Appeals in DC. This is the DC Circuit. So it's almost like the Court of Appeals is just, they're all in the same DC silo. Let's just leave it there. They continue. They say since November 18th, 2022, Jack Smith has been overseeing an ongoing criminal investigation about the interference with the peaceful transfer of power, encompassing the riots on January 6th. They give us some references here. On January 17, 2023 of this year, the government applied for and obtained a search warrant that directed Twitter to produce data and records related to Donald Trump's account. He's already been long suspended, although I think his account may have been reactivated by that time. At the same time, the government applied for and obtained, again from the same court, a non-disclosure order which prohibited Twitter from disclosing the existence or the contents of the search warrant to any person. You don't even get to tell Trump that we're rummaging around down through his DMs. All right, don't you dare notify him, lest he catch on. Based on ex parte affidavits, means notify the other side, just one side. The district court found probable cause, so the lower level judge, to search the Twitter account for evidence of a criminal offense. So a DC judge says, oh yeah, definitely, you have to search his Twitter account. He's an insurrectionist. Moreover, the district court found that there were, quote, reasonable grounds to believe that disclosing the warrant to Trump, if you notified about it, it would seriously jeopardize the ongoing investigation by giving him an opportunity to destroy evidence, change patterns of behavior. This is a lower level district judge writing. Or notify Confederates. Oh, so this lower level DC court judge is just like, all right, the warrant required, warrants approved. The Twitter can now turn over all of the information by January 27th. Non-disclosure order in effect for 180 days. And we've covered these before. What happens after these 180 days is they go and they request an extension and they just say, it's national security, you know, it's ongoing investigation. We need to continue this. And the judge says, oh, sure, another 180 days. We'll see you back here in 6 months. They say the government faced difficulties. This is the Court of Appeals writing. And again, this is like the way I would frame this would be like, you know, an angry father coming to protect, as a court of appeals is the angry father coming to protect his like all-star, you know, son in the DC court, the lower level court. So it's like, you know, let me go ask my father. And my father comes back out and he's like, yeah, my son's 100% right. So it's kind of has that feel to me. We'll continue. The government faced difficulties when it first attempted to serve Twitter with the warrant and the non-disclosure order. The government tried to submit papers through Twitter's website, but it was inoperative because Elon bought it. 2 days later, on January 20th, the government successfully served Twitter through the website. But on January 25th, when the government contacted Twitter's counsel to check on the status, the lawyer said she had not heard anything about the warrant. She's like, what are you talking about? So Twitter's kind of a mess right now, right? He just bought the company. He can hardly keep the servers running. Everything's like on red line. Everybody's like, my Twitter's not working. She informed the government that an on-time production would be a very tight turnaround, but she confirmed that the available data was preserved. Yeah, we still have that. And now Jack Smith wants to get it before Elon does anything with it. What happens if it's gone? On February 1, 2023, 4 days after the compliance deadline, which is the court served it on them, Twitter objected to producing any of the account information. Shout out to Twitter and Elon. No, we're not giving you this stuff. Although the company did not question the validity of the search warrant, it said non-disclosure order was facially invalid under the First Amendment. Why are you gagging us? We have free speech in America. Sorry, Elon. This is the DC circuit. You don't have anything. Twitter informed the government that it would not comply with the warrant until the district court assessed the legality of the non-disclosure order. Now, the district court also found reason to believe that the former president would flee from prosecution. The government later acknowledged, though, it had errantly included flight as a predicate in its application. So their search warrant was actually, or their non-disclosure application, they said, we need this non-disclosure so that we can't tell Trump, because if we tell Trump, he might flee. Oops, no, actually, we never thought that. And they say it's just a harmless error, and the district court did not rely on the risk of flight in its ultimate analysis anyways. Just a little oopsie. On February 2nd, Twitter filed a motion to vacate. The government moved for an order to show cause. Why Twitter? They say, Twitter, you should be held in contempt. We ordered you to get it to us by this date. You haven't done it. So Twitter argued that it violated our First Amendment right to communicate with its subscriber. Good for them. Hey, no, Trump is on our platform. We have a right to talk to him. The company said that compliance with the warrant before the resolution of the motion would preclude Trump from asserting executive privilege to shield the communications. And Twitter said, look, we understand we may not have standing to raise executive privilege. They nevertheless asserted this, said it's still our First Amendment rights and that you should stay our obligation to produce this stuff pending the resolution of these matters. The government raised two counter arguments. It said Twitter's compliance should not depend on these other issues being resolved, and the district court set some hearings and some motion practice was accomplished. Oral arguments took place, and they say that the district court, the lower level court, satisfied the requirements, said Twitter was in contempt. Sorry, you're 4 days late. There was an unambiguous court order requiring Twitter to produce these records. So the court gave Twitter an opportunity to purge its contempt by producing the info. When the court asked Twitter counsel, say, hey, can you get that material by 5 p.m.? She says, I believe we're prepared to do that, Your Honor. The court also asked the government what sanctions it would request if Twitter failed to comply. They said 50 grand per day, doubling every day that Twitter did not comply. That's our rotten government. The court adopted that suggestion. They said, you know, Twitter was sold for $40 billion and its owner, Elon, is worth $180 billion. Therefore, that sanction is appropriate. So what's $350,000 to Elon? This is your government at work. Unfortunately, ours. Accordingly, the district court ordered Twitter to produce the records by 5 p.m. if Twitter did not purge its contempt, escalating daily fines at that time. Twitter missed the 5 p.m. deadline. Although it did timely produce some records, they called it incomplete. Follow-up call, the government says, hey, this isn't everything we want. So they had another hearing. And then Twitter completed its production. They gave him everything they wanted because Jack Smith said, nope, we want that, we want that, we want that. Finally completed February 9th. They came out, they said $350,000 sanction. Twitter said, that's insane. The one final day, the last day, because it's basically doubled every day, $200,000. They said it was unjustified. The government gave us new search terms. They adjusted their requests. And they say, notably, Twitter still did not object to the sanctions formula. They just didn't want that last day counted on there. So then the district court came back out and they said, oh, perfect. We hate Elon here. I mean, he just took over our digital honeypot where we could control everything. So we're going to hit Elon with a $350,000 contempt fine. Twitter filed a timely appeal, and Twitter has already paid the fee. It's in an escrow account pending appeal. The government filed another motion, and yeah, so here you see, the government filed another motion requesting an extension of the non-disclosure order. Every 6 months that go by, they just ask for an extension. The government proposed to permit Twitter to notify Trump of the existence of the warrant at that time. The only limitation would be to withhold the identity of the case agent. The government changed its position about the investigations of Trump because it now became publicly available. The government also requested that in effect for another 180 days. So Twitter raises its arguments, says, first of all, this was an unlawful non-disclosure order, and we have a constitutional right to challenge this, and the lower court level abused its discretion, but the court is not going to agree with them. They say we have jurisdiction to handle this case, and we fly through some of the procedural issues. The government asserts that Twitter's First Amendment argument is moot. A lot of law here. So remember, oftentimes in opinions, we see that the issue is framed out for us. It's the IRAC formula, also known as IRAC. We see the issue framed out. We see the rules. Then we see the application of the facts to the rules. And then we get to a conclusion, IRAC. And so we're going through a lot of these rules. You see all these opinions here. They say, okay, all the rules are laid out. Now, we are unpersuaded by the government's narrow framing of Twitter's claims. They say this dispute is not moot. It is important. And let's get to the merits of the First Amendment claim. Twitter argues that the non-disclosure order is a content-based prior restraint on speech. And they ask about the governing standards. They say the government has two compelling reasons why we cannot tell Trump about this search warrant. The government, these were their arguments. One, preserving the integrity and the secrecy of an ongoing criminal investigation into January 6th. They say that was a big one. The government has a very compelling interest in keeping this secret. It's paramount to investigations so that there's no interference with targets. Therefore, we conclude that there was a compelling interest. It's also narrowly tailored. It only limits this to Trump. It's only limited to one Twitter account. And they find that Twitter's arguments to the contrary are not persuasive. Now, here's another procedural question they're raising. Twitter is asserting that the district court shouldn't have entered all of this stuff until they had a hearing on it, essentially. And again, they say these arguments are also unconvincing. Although the district court could have resolved the First Amendment issue simultaneously with this, it wasn't required to do so. They didn't have to go in any order. They say the district court reasonably concluded that the warrant and the non-disclosure order were wholly separate, and I didn't have to delay it. And so we reject Twitter's underdeveloped argument. They distinguish it against some other cases that Twitter brought up. They have some more compelling cases they say are better on point. And they also affirm the district court's contempt of a sanction. So $350,000. They say all they got to prove is an issuance of an order and disobedience with that order. Exaction of the threatened penalty if the purgation conditions are not filled. So they say, yeah, Twitter, you had a warrant, you had a non-disclosure agreement, you were not in compliance. At the hearing, the district court found, the judge was probably very angry, that you disobeyed a clear and unambiguous court order. You were required to comply with this by January 27th. And so Twitter was in contempt. They say that their argument that they substantially complied is not complied enough, and blaming the government for their failure to clarify only happened after it was already delayed. So you see where this is going, okay? It's incredibly one-sided. So this is the DC Circuit Court, my friends. This is the Court of Appeals, and it's just going to be like this moving forward. The district court did not abuse its discretion by imposing $350,000 sanction for like 4 days of being late. Penalties began $50,000 per day to double every day. To be sure, they say that schedule was highly coercive. As Twitter pointed out, after roughly 1 month of non-compliance, okay, this is how insane this is. It would have required Twitter to pay a sanction greater than the entire world's gross domestic product. The DC Circuit Court and the United States government, through Jack Smith, were going to sanction Twitter more than the entire gross domestic product of the entire world for not complying with Jack Smith's order. I kind of wish they would have just done it. Again, we're dividing by zero. They say, while a geometric schedule is unusual and generally would be improper, we uphold the sanction anyway because of this case. Twitter never raised any objection to this, and despite having several opportunities to do so. So they acquiesced to the formula, and they say $350,000 for, like, what is it, 4 days, or how's it work? 50,000, 100,000, 200,000, 50 to 100. 100 turns doubles to 2. So why did it get to 350? But they don't care. They say ultimately imposed was not unreasonable, given Twitter's $40 billion valuation and the court's goal of coercing Twitter's compliance. So they just say, no, it's just meaningless. It's just tip money for Elon. Okay, so it was 25,000 per day, not 50,000. Finally, we know that's how we got to the 350. So here they say, no problem. Oh, you add it all up. 50 plus 100 plus 200 equals 350. Got it. 3 days. Okay, thank you for the clarification. This is why I went to law school, okay? Don't put me in front of a spreadsheet with math. 3 days, thank you. 3 days, 50,000 for day 1, 100,000 for day 2, 200,000 for day 3. Add all those up equals $350,000. So it was a 3-day delay, not a 4-day delay, right? I said 4 days. So it was basically 3 days. And the last day, the third day, was $200,000. Whew! It's a lot. Whatever it is, okay? It's a lot of money. $350,000. But they don't care. It's Elon. Oh, he can afford it. He bought the whole company. So they say, in sum, we affirm the district court's ruling in all respects. Basically, didn't even need to write an opinion on it. We should have just rubber stamped it. The district court properly rejected Twitter's arguments, and the district court acted within the bounds of its discretion. Finally, the district court followed the appropriate procedures, holding them in contempt. Even though this is strange, Twitter had an opportunity to be heard and a chance to purge it, and so ultimately the court did not abuse its discretion in any way, and therefore Twitter is held in contempt. $350,000 sanction, which has already been paid. It's already in escrow, is now foregone over to the government. Jack Smith is not only attacking Donald Trump, the Democrats are not only attacking senior citizens in Michigan by going after the alternate electors. We also have Jack Smith going after private companies like Twitter, hitting them with sanctions and saying if they don't comply, it's going to be the same amount as the whole entire planet's GDP. So they're going nuts on this, and they're probably just getting warmed up. We see that there could be potential for indictment number 5. Special counsel is still scrutinizing finances of Trump's PAC, the Political Action Committee. He's also looking at the spending. We know that a grand jury that indicted Trump previously was also spotted meeting Tuesday at a federal courthouse in Washington. Investigators asked multiple questions about the Save America PAC, their enormous fundraising haul in the weeks between the election and January 6. Tim Parlatore shared this info with Politico. He says it's a laser focus from election day to January 6, scrutinizing whether Trump violated federal laws by raising money off claims of voter fraud that they knew were false. So there might be another indictment coming on this. They say here the prior indictment did not include any allegations of financial crimes. Rudy Giuliani and others have been under a lot of scrutiny there as well. So the prosecution continues, and the media is still having this fun conversation with themselves about the possibility that this whole thing is nonsense. As we've talked about, there are crimes that can be illegal. There are crimes that are illegal, and the solicitation of those crimes can also be illegal, presuming that the solicitation is connected to a crime. So for example, you can solicit narcotic drug. You can go to an undercover officer and say, hey man, you've got something here, and sell me something, and do this exchange, and boom, you solicited narcotic drugs. You can solicit prostitution. You can ask a question, and the asking is a crime. Okay, you don't actually like purchase the drugs, or you don't actually have intercourse with the person, but you solicit the thing. But the solicitation is related to an underlying criminal offense, which is what makes it solicitation. You cannot solicit, pass the salt to me. Can you pass the salt to me? Yeah, I solicit that. You solicit, you got to solicit something illegal. Otherwise, it's just asking for something. If you employ somebody, you say, hey, I have this project I need you to look into. Can you investigate this and go, do some research on this? And I'd like you to pursue this because you work for me and this is legal. That's not soliciting anything. It's technically maybe under the definition like you're soliciting for help or something, but it's not a crime because that person works for you. It's within the bounds of what they do as part of their daily job. And this is a very complicated concept for these people for some reason. And this guy's a lawyer, so-called. And apparently he used to work for Trump. I'm glad he doesn't anymore. But here's what he says.
He asked in an aspirational way. He went on to say, asking is not speech. It's not action. That's the heart of this, right? Speech versus action. Does that defense fly here?
Not at all. I'm not aware of the aspirational defense or the free speech defense to to a gang leader saying to two of his
Listen.
subordinates, "I need you two to please rob a bank for me," and they do it. That's aspirational.
Are you dumb?
But it leads to a crime, and that's exactly what Trump did with Pence.
Yeah, because it's illegal to rob a bank. It's not illegal to talk to your vice president who has a role to play in the counting of the electoral votes that was not ministerial. We know that because they made it ministerial in 2022 after all this happened. To ask the leader, the person in the position, to investigate something that is perfectly within the operation of their role, which it was. And we know that because before 2020, there was congressional research debates over this, and we've seen operations like this happen. And other people like Nancy Pelosi have even confirmed that if things went askew, they had contingency plans as well. So it's a very complicated concept for them. You can't solicit, it's not a crime to solicit something unless it's illegal. The underlying predicate crime has to be illegal. But did you hear how she smirked at this? Like, oh, I know, it's so stupid that nobody can even, they're joking around.
Speech versus action. Does that defense fly here?
Not at all. I'm not aware of the aspirational defense or the free speech defense to a gang leader saying to two of his subordinates, "I need you two to please rob a bank for me," and they do it. That's aspirational, but it leads to a crime.
It is aspirational. I guess they want a bunch of money.
What Trump did with Pence.
No, it's not. Not even close. These people are so delusional. It's crazy. But they continue forward. They're marching on with these various prosecutions. And I think, there might be a fifth one that is a financial crimes crime. And, I don't know where that's going to be based out of. Where is his super PAC located? Is this going to be a New York City charge? They would love to bring a Southern District of New York charge. Could you imagine if they got Judge Kaplan? So what happens if they just continue to do this everywhere we go? We thought that there were going to be 4 pieces on the chessboard: New York, DC, Florida, and Georgia, which is still coming in the next week or two. What happens if there's a 5th one out of Florida or some other places? Well, Matt Gaetz has a concept called presidential immunity and congressional immunity. Here's what he said.
You can actually bring President Trump in to give testimony to the Congress, and in doing so, immunize him. Now, there's different forms of immunity that take place at the committee level, subcommittee level. In some instances, for full immunity, you have to have more of a supermajority vote. But if you had a supermajority vote of a committee, like Speaker McCarthy could set up a select committee tomorrow that could bring Trump in and immunize him, and then we could proceed with the very legitimate investigative work that we're doing of the Bidens and the corrupt DOJ. Unfortunately, none of those things are happening. Instead, Congress is not in Washington, not assembled, and I think the timing is on purpose. No timing in D.C. is ever just a mere coincidence. And so right as Congress is leaving town, right as we're walking away from our equities, you see this acceleration of activity against Trump.
So yeah, let's be specific here, though. So immunize him from what crimes, even if he's under current indictment? Is that including even the obstruction claims? And give us some examples of how this has been used recently.
Well, it hasn't been used recently, but obviously we're aware of the ability for any person to plead the 5th. You can dissolve someone's ability to plead the 5th if you immunize them. And so Congress has this ability that's been recognized. It's even laid out in 18 U.S.C.A. 6002 and 6005. If folks want to look it up. But there, you've got the ability to say, well, we're hereby compelling your testimony. We're giving you immunity for anything you say to us and anything that would lead to. And so, for example, if President Trump came in and said, I'm here to give you testimony about the witch hunt, the abuse of criminal process that Congress has legitimate oversight equities to resolve. And if he were to say things to us, we could immunize him for that conduct that he were to discuss.
Does it take
very interesting idea. So think about this like in a regular criminal TV show or something, right? You've got 2 co-defendants. They need to flip one of the co-defendants. They've got person A and person B. They really want to get person A, so they go to person B and they say, hey, we're going to give you immunity. All right, you agree to testify against this person, and we're going to dismiss all these charges against you, and you're going to go free, right? That's kind of prosecutorial immunity. And now they'd say that kind of like what they did with the Hunter Biden deal is that this is a contract between Congress and the president. Just like when Hunter tried to scam his plea deal through, the executive branch tried to say that this was a contract between Hunty Poo and Daddy Vice President, and Daddy President now through Merrick Garland. It's just a private kind of contract. And so there's an exchange here. Congress says, we're going to immunize you. We're investigating all of this deep state corruption. Come in and testify. And everything that you tell us as a result of that is now going to be immunized. You're going to be granted this privilege. And so you cannot be prosecuted anything further from there. Fascinating idea. Would love to see if the Republicans got their head together and did something like that, but we'll see if it happens.